And hello, everyone, and welcome to the Copyright 2.0 show, episode number 355, the real episode 355 this time. I promise you, this time I'm dead serious. I forgot how to math last week. And my name is Jonathan Bailey. I am from the site Plagiarism Today, which can be found at plagiarismtoday.com, and I completely forgot to turn on my bottom third, so I cannot gesture to it wildly. But I'll do that now. But in the meantime, I would introduce you to Hailing from Parts Unknown, Attorney Evan Sherris, who is about to remind you that he is not dispensing any legal advice during the course of the podcast, and that you should not trust any free advice as legal advice. Anyway, don't be stupid.
Well, I guess you said it for me.
Well, yeah, I guess I did. Sorry.
Yeah, again, I guess I'll repeat it since you built me up. Anything I do say, of course, the podcast is just my opinion on recent events and not legal advice. So take it as such, and let's jump right into the stories we're going to be talking about today.
We know what the big story this week is. We know what the big story is. We can't wait to talk about it. Left Shark is in the news again this week, guys. Wait, I'm being told that is not actually true. Left Shark did nothing. Yeah, blurred lines. Come on, we all know it.
Blurred lines, right?
Oh God, I can't believe I just made that joke. I apologize to everyone on the planet for that. Yeah, blurred lines, though. Seriously, this is a pretty big day. You want to do a quick rundown of what actually happened? I'll let you take lead on this one.
Well, why don't you start by going through the other 6 stories,
yeah.
and we'll jump right into the...
No, we actually have 7 other. I threw this at the top. Yeah, we also, though, in addition to blurred lines, we will be going over, briefly, probably all these other things. The Village People... songwriter has successfully managed to reclaim and recapture 50% of his copyright in the compositions of his songs. An update in the GSU e-reserves case that could mean a quote-unquote whole new trial. Google getting a pretty significant win against the Mississippi Attorney General. Company VMware, well familiar for its virtualization, being able to run weird other operating systems on your computer, is being sued over GPL infractions. Florida is making a move that may, quote-unquote, unmask anonymous websites on the internet. We have also an update in the Kim Dotcoom case, and the sad epitaph of Aereo will be at the very end of this week's podcast. Now that I have finally found the English language again, please explain what happened.
Well, Pharrell Williams and Robin Thicke have to pay $7.4 million because, I was wrong. And I think, if I remember what your opinion was, is that they weren't close enough either, but I don't want to put words in your mouth. But a jury found that the song... blank. I'm in over the song. It's Good Girl, Blurred Lines. It's too similar to Marvin Gaye's Gotta Give It Up.
It's really bad when Blurred Lines is the one you forget the name of. I'm just throwing that out. How is that not beat into your subconscious from like a couple of years ago?
Well, I think maybe I thought Good Girl for just a few seconds. I didn't remember the name. Is because that's that like big falsetto moment that I remember in the song. So when I think of that song, that's the moment. But
word association, all that.
Yeah. So Blurred Lines was too close to the composition of Marvin Gaye's "You've Got to Give It Up."
Yeah, and I definitely went on record both here and on Twitter and home and everywhere else that would allow me to go on record. Random strangers on the street, kids at amusement parks, anywhere that I could legally talk about the case. I basically said that I didn't feel that the two were close enough, that there's a lot of similarity in music, and that derivative work in music is, of course, a very subjective thing. And I didn't feel like, to me personally, this one didn't quite reach that level. But, the jury, as you said, disagreed. They ruled differently. And as I said, this is a very subjective nature. We talk about, there's a lot of things in copyright that are subjective. Fair use at times is very subjective. And at times, what is a derivative work versus just, an inspiration and something that's not infringing is also at times very, very subjective. And here we have one of these cases where a jury found something different than what I did, and that is perfectly reasonable. That is their prerogative. But it does show how this type of thing is very open to interpretation.
Right, and you've basically espoused the narrative that Howard King, attorney for Williams and Thicke, was trying to convince the jury of, which is that there is so much similarity in music, which is true, that you can't possibly think that this is enough of a ripoff to find our clients liable, that this is simply a case of inspiration, like thousands of other songs before. But unfortunately, that's not what the jury found. So let's take a second here and explore maybe some of the reasons why this went from a case of arguably inspiration to a jury finding liability.
Well, I think, yeah. Well, I mean, one of the things that leaps to mind is Robin Thicke and Pharrell Williams. Robin Thicke, in particular, did not do himself any favors in this case.
That's right.
If you could win a lawsuit by shooting yourself in the foot and then stick it in your mouth, he would have won. I mean, clear hands down winner. I mean,
so,
yeah.
We talked about it a few weeks back about how in his deposition he said a few things about being really inspired by Marvin Gaye and then tried to really walk that back in trial. He talked about being high and lying about his inspirations and lying about being inspired by Marvin Gaye in the past. And so you're coming to the stand as a liar, and so right away the jury doesn't like you. They don't want to believe the things you're saying if you're starting out saying, oh, when I said that before about Marvin Gaye being really inspirational to me, I was really just trying to take advantage of the goodwill that would bring me.
Yeah.
Oh, and also it was the Vicodin.
It was the Vicodin, too. Don't forget the Vicodin. The Vicodin played a role here.
Right. So you can never forget, the likability of somebody when it's a jury trial. Juries are filled with humans, and humans were very emotional people. So sometimes that can sway you when the balance may or may not be equal.
And that's one of the things in this type of case is I really do think from the outset this could have gone either way. A reasonable person could have looked at these songs and felt either way.
Mm-hmm.
I don't have any prejudice against anyone that feels opposite of me. I can totally see where they're coming from and don't think they're nuts. The thing is this, when you really make yourself the enemy of the jury like that, they sometimes work the logic backwards rather than forwards, They sometimes try to figure out why they think you shouldn't get out of here without paying money rather than, well, should they pay money.
Right.
And that puts you in an unfortunate position when it's like this, where it's kind of easy to do that. And I'm not saying that's necessarily what happened. I don't think that we have any clue what the jury actually was thinking.
Don't. But all we can do is speculate. And that's something we can do. As a podcast, that's all we can do. And we'll actually get to a point in the trial later where there was some speculation which was stricken from the record, and it goes to a little lesson about what you can and cannot do in testimony. But let's move to maybe a second thing that I think may have swayed the jury, which is the technicality of composition versus the sound recording versus blurred lines as a sound recording. So a lot of effort was put into ensuring that the proper two items were compared. And most people who hear about the lawsuit who don't pay attention to what is actually happening in the proceedings will take the two songs and they'll play them next to each other. But as we mentioned last week, that's not what happened. The Marvin Gaye family doesn't own the sound recording, the song that you hear in Got to Give It Up. They own the composition, so the music sheet. And there's some very important distinctions in what is in that sheet and what actually ended up in Marvin Gaye's song, because during the course of the sound recording, they added things like percussion, that cowbell that's really similar in both songs, that is just not in the composition. So that's really not part of the comparison at all. So when it comes down to the case, although the jury is instructed to compare the two, and we ended up listening last week to a sound recording version of strictly what's on the composition, which ended up sounding really weird, you know that it's likely that each one of these jurors who have access to YouTube and have access to Spotify when they're kind of not sure and want to balance the equities, they'll listen to both sound recordings, and I've no doubt that bleeds into their decision at the end of the day, even though they can't really come out and say it.
These jurors are human. They went home at some point during the trial. They were not sequestered in a soundproof room where they could not access these songs. And also, these are both very popular songs. There's a very good chance these jurors, at least some of these jurors, are intimately or directly familiar with both of them.
Right, and that's part of the jury selection process. But
it's not always
somebody
perfect.
wants to be on this trial, and it's a very high-profile trial. So an average person is thinking dollar signs in interviews after it.
No, it wouldn't be, but okay.
So you could always say like, no, I haven't heard it. And so at the end of the day, I think you're right. I think they have heard it.
Yeah, it's almost certain. You can, with jury selection, you can whittle down people that are like the rockin' hard Marvin Gaye and Robin Thicke fans.
Mm-hmm.
But if you try to make it so that people who haven't heard either song, you pretty much are stuck getting 12 guys in a cave somewhere that don't contact the Amish. Okay, 12 Amish jurors is probably your best bet at that point. Because blurred lines alone was everywhere. You know. You could not avoid it even if you tried. And the result of that is you're going to be very hard-pressed to find 12 people that have never even heard of that song. So you have to you weed out the people that definitely would be obviously biased one way or the other, but yeah, at the end of the day, they know these songs. You can't avoid that.
Yep. So the last thing I'd like to talk about in what could have swayed it either way was the testimony of the competing musicologists. And so... I don't know if you know what a musicologist is, but a musicologist...
I'm guessing they're an ologist for music.
Very, very astute. They're experts or self-proclaimed experts in music, and a big part of their job is to testify in jury trials about the little things that go into the recognition or the creation or the the comparison of two pieces of music. And
these are the guys that think the 4 chords bit by Axis Awesome is the funniest thing ever produced in all of history. And I think it's pretty funny, but yeah, they really enjoy it,
Right, because it breaks down, some of the similarities. So, Judith Finnell is a Berkeley-educated head of musicology consulting firm. And let's go with some of her testimony to see what could have swayed the jury one way or the other. So she talks about something called a signature phrase. And that's the immediately identifiable single phrase of each song that you recognize. And so she takes these two songs and says, like, hey, let's look at these two and see if we can compare them. So Marvin Gaye's I used to go out to parties, which is I used to go out to parties. And Blurred Lines, it's gonna take a good girl. She's like, hey, these are stunningly similar, she says, and these are her quotes, and highly unusual, she testified. So this is your persuasive way of presenting to a jury how unique of a situation this is. She says that they both begin with a repetition of the same note, and which is, quote, one of the most important considerations in comparing melodies, and end with a single word, girl, and dancing, sung over several notes. And so these are little ways to start to break down music and compare it to a simple level for a jury. And I think she was pretty convincing when you take those two signature phrases, because, a signature phrase, what does that mean to a jury? But you explain how important it is, and they're like, yeah, you know what, that is the line I remember. And so it goes to show the importance of a great expert witness.
Yeah. And that's one of the things about this case is neither side was wont for high-powered legal teams or high-powered expert witnesses. Everybody had, their hired guns there. So it wasn't lack of funding. This wasn't, one side beating up on an underfunded opponent. But yeah, I do think that it's possible, if not probable, the Gaye team did have the more convincing expert witnesses.
Yeah, I think that's probably what ends up deciding the case, is who has the more convincing expert witness.
Yeah.
And they talked about more than just those one lines. They go into other parts of the songs, like the keyboard and the bass interplay, was one of the things talked about. One of the experts discussed that the songs featured both bobbing keyboard and bass lines with similar rhythms and moments of silence. The gays also brought up a musical expert, Harvard professor, which always is a great line when you're introducing yourself and your credentials, which is something an expert witness has to do. Ingrid Amonton argued that Gay's bass line and its pairing with the reggae or ragtime-influenced keyboard melody was extremely unique for Marvin Gaye's songs, so that when she would later argue that Blurred Lines copied that combination of a reggae or ragtime-influenced keyboard, you can't really say that you were just inspired by Marvin Gaye generally. You really had to be listening to this specific song if those are the similarities between the two.
Yeah. And that's just it. It's a very difficult issue to explain to lay people. And we talk about how, like with the Google Oracle case going on, and how apparently we've been accused of messing up APIs repeatedly now. Music is just as complicated at the end of the day. It really is. It's just as complicated and just as opaque, and it requires just as much expertise to explain it. So, kudos to any expert witnesses that can break this down and make it, intelligible to anybody that has not studied music. My hat is off to them. But what are your thoughts though regarding the long-term impact of this? Let's start shorter term. What's next in the case? What's probably next?
Well, what's next in the case? I think you're going to see some sort of appeal on the music issue, on what was played. But I'm really not sure. I think this really could be the end of this. I'm not sure if that's going to go much further. I think you're going to see a payout. I think you're going to see a settlement.
Yeah.
You're going to see, because they're going to try and go for an injunction to stop the song from being played, but that becomes a little bit more complicated because there are ownership rights in the music studios who weren't part of the suit. And there's also some issues of the music studios actually owning the sound recording of
Blurred Lines.
Of not Blurred Lines.
I'm sorry, got to give it up. Sorry, the other one.
But
Motown.
But if you'd give me just the chance here, John, I want to talk about one more part of the case.
I'm sorry. I didn't mean to jump ahead of you. Go ahead, please.
It's okay, and this was really covered well by the Hollywood Reporter. After they got onto the comparisons of the melody and the comparisons of the inspiration, even though I don't think it was as strong, you also want to try and compare the lyrics. And so part of the testimony was that both of the songs, center on transformation. And the narrator or the story of Got to Give It Up by Marvin Gaye is the transformation of a wall hugger, someone who's at the club and not dancing, into an enthusiastic dancer. While in Blurred Lines, the good girl will transform into as the Hollywood Reporter puts it, a sexually liberated girl. And at this point in the trial, though, this is where I thought this was just really funny. The judge cut her off, pointing out that this person is a musicologist and not a literary expert. And so this is just a little anecdote on the differences on what an expert witness can testify about. But they ended up talking a little bit more about it, how Gaye's lines was move up, turn around, shake it down, into Thicke's shake around, get down, and get up. So these little things, when you start putting them all together, it sounds more and more similar. And then finally, the judge was part of this lyrical comparison, and when they were getting to the point where the rapper in the Blurred Lines song says, and cover your ears to anyone who's under 18, I'll give you something big enough to tear your ass in two. Well, the judge refused to say that, so I thought that was pretty funny.
But we will say it on the Copyright 2.0 show, apparently.
Right.
But yeah, and it's a situation where you're staring at a lot of dots, basically. You've got a lot of dots, a lot of points of similarity, and how you connect those dots determines how you feel about this case.
Yep.
Do you connect those dots in saying they were actively trying to plagiarize and rip off and sort of remake the original, or was it just a case of they were drawing some vague inspiration from it and the overlap is the natural byproduct of that? How you
Right.
connect those indisputable dots of overlap is how you determine this case, basically. And you've got two sides painting very different pictures of how those dots should be connected.
Exactly. So, short-term implications.
Sorry, I did not. Like I said, I did not realize there was a fourth. My apologies.
It's all right. Don't worry about it. This is bad for the careers of Rob and Thicke, and well, I mean, I think T.I. will be fine, and I think Pharrell Williams will be fine. But this has got to be a big
Yeah,
emotional.
Pharrell Williams probably tried to pull out his checkbook in the court. Say, okay, is that really all we got to do to make this go away?
Yeah. I think this is got to be a big. This is a big career blow for him. This was his big song, and to really have it taken away from you like that, even if the financial implications don't destroy him, which they might because he's also going through a divorce. You look at the Verve and the song Bittersweet Symphony. I don't know if you remember that one, and how that was just a smash hit. It was going to launch the band into the stratosphere, and then they get sued by the Rolling Stones and they lose, and they're not heard from again. So it's I think this is going to be.
To be fair, though, Robin Thicke, we've already not heard much else from him. He's had some time, and not much else has come of his career already. So, just saying.
Right.
I think he may be done in more by Miley Cyrus twerking on him, and while he was wearing a Beetlejuice costume, than this lawsuit. And that whole situation was just completely outrageous. But I understand your point. This is definitely a bigger hit for Robin Thicke, who really this is, as you said, his major hit, his big thing, and it kind of as you said, takes it away from him, but also it's likely to have an impact on future royalties for it. I mean,
yeah, of course, the royalty stream is going to be
pinched a little.
Yeah, big time, if not completely dried up. At least until ownership is settled, and now they might have to get agreements with all kinds of with the new potential owners, et cetera, et cetera. There's a lot of potential issues. There could be a copyright transfer and transfer of royalties in exchange for in a settlement, in exchange for maybe a reduction in immediate damages. They might be like, okay. Would you take a copyright transfer in the sound recording in exchange for maybe a reduction in the penalties? We'll see what the creative settlement comes from this, because there probably will be one.
And that's kind of the thing here, is now the gay estate has the upper hand, very clearly. I can imagine the lawyers for Thicke and Williams are going to appeal to the current judge to either set aside the verdict or to reduce the damages, as we saw with the Jamie Thomas case, where they keep going to the original judge hoping that this award is so egregious, so outrageous that it can be set aside. But I don't think it quite qualifies for that.
No, it's pretty well tied into the evidence of.
Yeah, it seems that way to me too. It's not like the Jamie Thomas case where the award was very eye-popping given the situation. Here, the pieces fit.
Right, you're not dealing with punitive damages either, so it's hard to argue that something is out of proportion. You're dealing with compensatory damages of that is rooted in actual accounting of how much money a certain song has made and how much income someone else has had from it. There may be some arguments to be made that a lot of their money from their touring and their album sales can be attributed to the rest of their songs on the album, but good luck with that. Everyone knows this was a one-hit wonder tour.
Yeah.
Which
the
is
blurred lines describes the rest of the items on the set list at this point. But
yeah. That was good.
But so I don't see those arguments working. There may be an appeal here, but one of the things that came out in the earlier parts of the trial was the judge really, as we noted, was being, I don't want to say heavy-handed, but ruled repeatedly against the gay estate on just about everything you can think of, it seemed. It seemed like nothing was going the way of the gay estate until this jury award. So I'm trying to conjure up what Thicke and Williams are going to appeal on. We already knew what the gay estate was going to appeal on. They already had their appeal pretty much written, I think. But Thicke and Williams are in a different position here. They don't have as many elements to appeal on, and as you said, now that the gay estate has the upper hand, settlement seems almost inevitable here. There'll probably be some limited legal maneuverings between now and then, but I expect they're already meeting to discuss a settlement even as we're talking about it today.
Yeah. So long-term impacts on copyright and the music industry. I don't know. I don't know.
I don't know.
I think this is probably an outlier. I still think that the costs behind this kind of suit just limited to just really the situations where you have the estate of one giant artist going after the estate of another giant artist. It doesn't really help or impact smaller artists having their work stolen. So I don't think you're going to see a huge impact moving forward, and I think it'll just be an outlier case of when it really got to the end of a jury, and
yeah,
songs are so different and juries are so different that I don't think this is going to be a big.
You could line all this up, exact same defendant, exact same plaintiff, exact same defendant, exact same set of facts, put it in front of another jury, and have it go a completely different way. I mean, it's really that subjective, honestly. I mean, you change around some of the expert witnesses, you tinker with just a few odds and ends, and it could really have changed. You could have made it so that Robin Thicke wasn't on Vicodin and drunk the entire time he was talking about Marvin Gaye the first go around. You could, what I mean? There's so much it could have changed this case and given it a really different
very
outcome.
fact-intensive case. So
yes, it was, and I don't see this having drastic implications for other cases. There's like on sites like Tech.Dirt and so forth. There's things like this jury just made being inspired by a song illegal, and no, I don't think
it's ridiculous.
That's not what happened here. This is not where we're going. It's a very, very fact-intensive case, as you just said, and very, very much dependent upon the things that took place within this courtroom, I think. I don't see this having a broader impact. It's gotten a lot of publicity because of the people involved and now the damage award, but that doesn't mean it's going to be a case that we're studying in law school 10, 20 years from now either. It's a great case study in how to run a trial, I think.
I agree.
It's a great case study on that, on how to run a trial, how to present expert witnesses, and how to especially present testimony related to music. But as far as, fair use, changing, landscape shifting, legal opinion here, I'm not feeling it.
I agree.
I don't. Well, you want to move on and talk about some other stuff? Let's move
on to our next story, which is the Village People Right of Termination story.
Yeah, this is interesting. Now, copyright today, since the latest Copyright Act, gives people who sign various types of licenses and agreements. It doesn't actually cover outright copyright transfers, but exclusive licenses and other agreements have the right to terminate those agreements after a period of time, specifically 35 years. So a lot of stuff from 35-ish years ago is coming up for copyright termination, and among that is a lot of the Village People's music. You probably know them best for YMCA, Macho Man, and a bunch of other hit songs that are played pretty much at every annoying office party. That's unfortunately the legacy of them, it seems. But Victor Willis, one of the... Huh?
John, let me stop you there for a second, because I do believe it does also...
Oh, it does apply to copyright transfers?
It does also apply to copyright transfers.
Oh, it does, okay.
Yes. I believe the statutory language is Section 203, in the case of any work other than a work made for hire, which is a whole other story.
That's what I was thinking of.
Exclusive or non-exclusive grant or of a transfer or license of copyright.
Yes, you're right. You're right. I'm sorry, I was thinking work for hire, and I totally slipped a gear when I was speaking fast. Thank you for the catch, though.
That's no problem.
That's why we're here, to get each other's back on these stories. God knows we would say a lot of stupid things on our own. But anyways, yes, correct. It does apply to transfers, not work for hire. All right, but yes. But basically speaking, you can undo that now. And he applied for it, but there was an issue at hand with him. He felt he was simply a co-author, a 50% author of the songs involved, including YMCA. But there was a wrinkle in this wrinkle in this product. There was another man involved, another quote-unquote co-author in this case. Now, Willis actually had a long road to begin with, to start with, because his co-authors, neither of them, or the other one, or neither of them, wanted to go along with him.
Yeah.
They did not want any part of this copyright termination thing, but Willis did. And first, he had to win the right to do it without his co-authors, which was a legal fight into itself.
You'd think that is this the first time that this is happening, right? That
Yeah.
authors want to terminate, and well, the answer is yes. You know?
Yes, actually, it is. 35. We're about 35 years on the nose from the Copyright Act.
Right.
So there you go.
This part of the Copyright Act is one of the reasons I became really interested in copyright in the first place, because I found it really fascinating that this is while I was in law school, so we were on the cusp of this, like, brand new part of the law, which is that this right of termination that was, made, 40 years ago is finally, coming to maturity here, and people are going to be able to, start taking their songs back. So what's going to happen? Are we going to see a total upheaval in the classic rock world where, it's going to be a renegotiation to be able to play the songs of some of my favorite 80s bands and late 70s bands, et cetera, et cetera.
Well, thanks a lot, jerk, for that reminder that I am about to turn 35, and therefore the stuff that was popular and written when I was born will soon be coming up for copyright termination. Is that going to be the metric for my life now? The songs I love coming up for copyright termination?
Yeah, you could probably start tracing that back. The older you get, and as soon as it starts coming to, like, the Backstreet Boys, taking their songs back, you're going to be like, okay, I'm old.
It's time to go out to pasture and just not come back. It's over.
So let's set the foundation really quickly, a little late into the story, but
okay.
This is called the Right of Termination. A new author, when he comes into an agreement with a publisher or a record label, he's got almost no negotiating power.
Especially if he doesn't already have a career or a name for him or herself.
Especially, of course. And, they're presented with a contract with terms that are probably written before the negotiation even starts and probably aren't going to change after it ends, even if there is a negotiation.
Mm-hmm. You're signed his contract. Whee! That's usually how it works.
Mm-hmm. They're offered in advance. They're like, yes, monies, please.
Money, I am hungry.
Yes. So that's part of the reason why this clause is in there, it's because they wanted to give a chance, 35 years later, for some of these authors to be able to take their work back. And so they have a statutory right of reversion, basically 35 years after the publication of the song.
Yeah.
Which means that if the only way it's come up already, because 35 years after 78 is 2013, which is when they could start filing, which means that that's how we're starting to see this now, because usually these things take 1 to 2 years. It's 35 years after publication, which means that the song had to be published when it was written. So, or 40 years after the grant of right is made. But I don't think that number is so important, because if it wasn't published and it wasn't popular in the first 5 years, then there's probably not much value in it. So 35 years is the big number.
Yeah. But as I said, with this case, what was interesting about it is, A, he won the right to do it, which was important. But then there was a claim by the record label that he was only deserving of 33% because there was another gentleman, Henry Bololo, I guess is how you say that? Henry Bololo, who the record labels claimed had written the songs in French, and that the Village People, basically, including Willis, just translated them to some degree.
Who can terminate? It's the author. Prove you're the author.
Exactly.
So, we had this issue of fact as to who was truly the author, and so another situation of maybe like a fact-based circumstances that I don't think it's going to be a big precedent setting. It's more, this is just an interesting story.
Yeah, it's a fascinating story, and once again involves songs we all know, and you will never get 12 people who have never heard it either. But
yep.
But basically, the jury ruled that Bololo did not write the songs. He is not an author, and that his name should be removed from the writing credit from the 13 songs he was claiming. And that means that Willis will be getting 50% of the copyright upon the termination. And once he gets that, that also gives him licensing and other opportunities, because he has, enough of a share there to start taking more unilateral action and getting more of the revenue, basically.
Yeah, that's
So
great.
it's all good news for him.
It's all good news for him. The only thing I really have to add to the story is, if you want to know a little bit more about the right of termination, you got Section 203 of the Copyright Act. If you want to go look that up on your own, there's some interesting nuances into how exactly you get it terminated and how many
Yeah,
times,
and
how
there's a
many bites of
whole
the apple you have about trying to terminate it, and et cetera, et cetera.
there's a whole bizarre, almost mating ritual there that you have to do. It's a weird legal dance. Like within a certain time frame, you have to file this, and then you have to file that, and then there's a time for a challenge, and it's a very bizarre process, and a lot of it's done through the U.S. Copyright Office. So it's very weird. Yes, it's one of the weirdest laws, parts of the copyright law I can think of. Parts of the current. Well,
Yeah, well, there's work for a lawyer to do there for sure.
there's a lot of work for lawyers to do, especially in cases like this where there's going to be an interest in defending it. Well, moving on to Georgia State University and the e-reserves case. This case actually could have other bearings and other implications, especially for colleges and universities here, because Georgia State University decided that in some cases they didn't feel like paying for course packs. So they encouraged their professors to use an electronic reserve they had created. And they argued that basically this was a fair use of the textbooks and so forth that they were legally purchasing and using. Well, publishers might say disagreed.
Exactly. And, what was a big part about that fair use determination was the fact that a lot of these excerpts were not available to be licensed, which now comes back to play a very interesting role in the current filings.
Well, and what's interesting is GSU won pretty handily in the district court.
Right.
They got all but, I think, like 5 of the 99 cases ruled to be a fair use or not infringing. In fact, some of the cases didn't even make it to a fair use test. But the 11th Circuit went, whoa, Chief. Let's back that up a little. Your fair use analysis, to be frank, kind of sucked.
Mm-hmm.
Basically called out the fair use analysis of the lower court, kicked it back like it was a soccer ball, and now the publishers are saying, hey, wait a minute, all these years have passed. We filed this in 2008. We need updated evidence. We need new evidence. Now you're thinking, well, why would they need new evidence? That seems irrelevant. Well, as you pointed out, one of the reasons that the publishers lost the fair use analysis was because, like you said, they didn't have license. There was no possibility to license these.
So right, they couldn't argue that there was a lack of commercial gain because they weren't going to pay the amount of money to license the whole book anyways if they only needed a small excerpt. But because of new precedent in Ex parte Young, which basically says that you really have to address continuous and ongoing violations of federal law, you kind of have to take into account the relevant facts as they currently exist upon remand, because the court instructed to really redo the whole analysis. So with a new analysis, they want to say, like, hey, we want to bring in all these new facts too.
Now, what has happened in the last 5 years to the textbook and the publishing industry in general? A lot more e-licensing. That's what's happened. I'm pretty sure now virtually every book in the e-reserve would have at least a possible licensing source. And that is what the publishers are hitting at, I think, with this request for new discovery.
Yep.
So.
Well, they've been making sure to offer licenses, I would imagine, for every item at issue here.
Oh, wait a minute here. Hang on. Let's start mashing some buttons. Yeah, you're probably exactly right, and not just at issue here, but that they think might have ended up in the e-reserves period. And you have to wonder, Georgia State University did this as a cost-saving measure. Is all this litigation really saving them money now?
I mean,
at what point would this be a Pyrrhic victory for them? I'm just wondering.
I'm not sure, what their end game was. 5 years of high stakes copyright litigation is going to cost
That's
millions of
7 years. This was filed in
dollars.
2008. It's 7 years.
7 years. 7. Yeah, it's not. It's going to cost you millions, and I don't know how much licensing can really cost you
I
for
know
little
textbooks are
excerpts.
expensive,
Yeah.
but
Uh,
I've never paid millions for mine. I'm just throwing that out.
these things snowball and they become personal. So
Yeah. All that, and also now I think they're just trying to avoid damages too, which could compound the already high bills. So,
right, because with the Copyright Act's fairly liberal standard for the grant of copyright, for the grant of attorneys' fees, losing is not really an option.
no, it's not. And
You know.
so that they're going to keep fighting it until as long as they reasonably can. And but now, like I said, we could be basically heading to start this whole thing over with new evidence 7 years later because of, like you said, the need to update and address the ongoing infringement. So yeah, there we go. We're going to be sort of hitting. Looks like we might at least be hitting reset on this.
We might.
So the Attorney General case.
I hope not. For the judge's case. For the judge's
Yeah, the judge might retire before this case is over. Just warning you, judges do eventually retire. Might not seem like it, but they do.
All right, so yeah, let's move on to the next
Yeah, the Mississippi Attorney General Jim Hood found himself in the center of controversy. He has been really aggressively investigating Google recently, sending lots of subpoenas. It says here in 2013 he sent a 79-page subpoena. Now, I have not seen all the subpoenas out there, I admit, but I've read a great number in my line of work. I don't think I've run across a 79-page one, though.
Well, that's an integral part of what makes this story so freaking interesting.
Yeah.
With 79-page subpoena, ends up being inspired, as we talked about it with the Marvin Gaye blurred line situations. I guess there's a little bit of a difference between being inspired and straight up copying, which is the situation we may have had here with a lot of the legal language contained in the subpoenas and in the requests and in all the legal documents filed by the Mississippi Attorney General coming from certain lawyers in the private sector.
Yeah, specifically the Motion Picture Association of America, the MPAA. Basically, the allegation is that the MPAA was a little too chummy, as you said, with Mr. Hood, and as a result, Hood's relationship with the MPAA was improper, and therefore the investigation into Google is improper. Now, he had already called a quote-unquote timeout, which I'm reasonably sure a timeout is not an actual legal term. I think that's used in sports. I'm not much of a sports fan, but I'm reasonably sure that's a sports term, not a legal term. But
the timeout is an age-old controlling precedent in tag.
Okay. Yes. Well, yeah. There too. Yes, and also widely used in a variety of other playground games as well. It sits there next to Not It and Who Smelt It Dealt It, I believe, and the childhood legalese.
Yeah. Oh man, good times.
Okay.
Back on the schoolyard when laws had value. So this comes down to The Verge's reporting of something called Project Goliath, a quote secret Hollywood project to investigate and discredit Google on issues of copyright and web freedom. But this is all, like you reported, has all turned on its head because the Attorney General had some of the inspiration he had dusted up, and all of a sudden he's calling timeout, and we're a few weeks later here, and more has been exposed, basically, as to his just exactly how cozy he was.
He has now been barred from filing any more subpoenas against Google, basically.
Right, he lost a major legal battle in terms of that. His ability to issue the subpoenas is on hold.
Yeah, at least.
And Google's requirement to follow the subpoenas.
And this came from a federal court in his home state of Mississippi. So he, Google is no longer obligated to respond to his subpoenas, at least for a time, and he is no longer able to send them. So yeah, his timeout now definitely actually has legal precedent.
Yeah,
See, that's how it works, right? He called a timeout and he got one. Oh man, but it's an interesting case, and it's.
I agree.
It points
the
to
injunction is still under seal, so I'm interested to see if he's actually, for lack of a better way to put it, if there's any smackdown coming his way, for what's happened here, or is this just a simple, okay, this is you don't have to do this, or is there calling out inappropriate behavior?
Yeah, I mean, because it is possible that he was prevented from doing it without really accusing him of any wrongdoing. You can say, okay, that subpoena was egregious. Don't do it again. Basically, is what it comes down to. Versus, getting called on possible ethical violations and so forth that could really have a drastic impact on his career. I mean, this is how you get disbarred in some situations. I don't think that's going to happen here. That's an extreme outcome, but
I don't know. I don't think it's that extreme.
You don't?
I don't know honestly, I don't know Mississippi ethical rules, but in Florida, the ethical rules are very strict, and I would not be surprised to see people filing ethical complaints. This is the kind of thing that you have your tech open source people, and organizations that would love to jump on this and say that this is, an example of a kind of crony capitalism situation, and we're going to file an ethical complaint against you.
Yeah. Well, speaking of things the open source people like to jump on, Gpl violations.
Right.
Now, are you familiar with VMware as a company and their products?
I'm not. Why don't you tell me about them?
They do virtualization. Basically, one of the things where I'm most familiar with them, I'm sure they have other products, is they have they use products basically if you wanted to divide like a physical server into multiple fake like virtual servers basically. You would use a VMware product to do that. It basically sits in between, and you can install multiple copies of the operating system, and they all get their own little CPU and RAM, and run multiple instances of Linux or whatever within them. And the idea is basically it lets you carve it up. I also know they have tools for doing things like if you want to run, Windows on a Mac or something like that, or run multiple operating systems on the same PC, you can do it with that. But that's basically it. Virtualization. Creating multiple virtual machines out of just one physical machine. Well, they have been sued, have they not?
They have been. By
a Christoph Hellwig, which has got to be one of the most German names I can fathom right now.
That's a name for like a fictional Nazi character, Hellwig, it's like I could definitely see him in like a Nazi zombies antagonist role.
Or in like one of the monster films, for example, Professor Hellwig. That's Christoph Hellwig to you. You can easily see that. But anyways, I'm sure he's a lovely guy. He's a Linux developer. How evil can he be?
I'm sure he's a nice guy. So the essentials of this case boils down to a copyright violation, and the violation of a quote-unquote open source or public license, which is close to what we most people know as a Creative Commons license.
Yeah, Creative Commons was kind of spawned to be a open source-like alternative for other creative works. Because the open source license, the GPL, is meant for code, and it's written very intensely for code. Creative Commons is written more broadly, so you can use it for text and video and audio, etc.
Right, but at the end of the day, the scope of these, or the idea behind these licenses, is that you can use it. And like I'm talking to you, John, and I'm talking to the listener, and I'm talking to a company. We put our our sweat and our blood into this, but you know what? You can use it if you follow a few conditions. And this was GPL version 2, and there's different versions. Just like a Creative Commons license can be like, okay, you can use this as long as you tell everyone that I made it, or you can use this as long as you don't make any commercial use out of this. The GPL said that you can use this as long as you follow conditions A through F, and one of those conditions is that you can't then develop a third product based on this and then stop other people from using that product and commercialize that product, and that's what we have here.
Yeah, you have basically the idea is if you take this code and build something new with it, you have to then release that source code under the same license. It's meant to be kind of a way to perpetuate the license into forever. And apparently, VMware released a product called ESXi. It's capital ESX lowercase I. I do not know anything about that particular product. I'll be honest. I probably should have researched. That made some use of the Linux kernel code that Christoph Hellwig claims to have written and be the copyright holder of. And then, according to him, they did not complete that obligation of releasing the new source code publicly. And so he is suing. He is getting backing from the Software Freedom Conservancy. It's a charity that supports, it says here, it supports open source software projects. They are funding it through a grant. They are funding his lawsuit, and it's being filed in Germany. It also is another interesting thing. So, yeah, you don't see many of these types of
German copyright law.
No, I don't know squat about German copyright law either. I know it's in the EU, so therefore any EU regulations would apply. Like I know the European Directive on Electronic Commerce would apply here, and that governs their notice and takedown system. But other than that, yeah, I'm lost. But
well,
yeah, so basically,
I think other than the the basics of this, which is that they're basically going to have to prove that this GPL license 2 was not followed, and that comes down to, I guess, the code that they ended up quote wrapping their code around. I think what the accusation was exactly is that they wrapped their VM kernel, which is part of its virtualization software for servers, with the open source code, and then they ended up using that in some sort of commercial capacity.
Yeah. So we'll be monitoring that. I'm sure we'll hear more about it. But VMware, for its part, by the way, has denied any wrongdoing, and it said they are staunch supporters of open source, and they will defend this lawsuit, which is the typical, usual bluster you hear.
So I think that brings us to the Florida case.
Yeah, this is interesting. New legislation in Florida. Hey, we don't talk a lot about states on this show because states...
For a good reason.
For good reason. They usually don't matter.
Not only do they generally not matter, but they don't matter because it's generally unconstitutional for them to legislate in these areas because they're preempted by federal copyright law. And I think that was the first thing I thought of when this proposed legislation was on the table. So the story is that they're moving to, quote, unmask anonymous websites in order to combat online piracy. Florida lawmakers are considering a legislation which would make it unlawful to run a website anonymously if it offers, quote, commercial recordings and videos. It's basically to end up preventing, the Kim Dotcoom situation where people are running these names under pseudonyms, etc. And the bill is still under considerations, but I personally think that there are huge constitutional considerations. Both First Amendment, in that, you really is going to have to pass a constitutional muster as to forcing someone who's trying to speak to reveal who they are, and you have to have a good reason for that. Anytime you're trying to stop speech, you got to have a good reason for it. And so we'll see if that passes any constitutional muster based on the language they end up putting into the actual statute. And the second thing is the whole preemption issue, is that it depends how far this ends up going in touching issues of either copyright or different federal communications, or whether it's going to impact the entire economy, which could have a Commerce Clause issue, because there's something called the Dormant Commerce Clause, which is basically that since the federal government has authority to regulate interstate commerce, then if a state does something that has a substantial impact on interstate commerce, it could, in reverse way, be unconstitutional. Is that Florida can't do something that's going to stop someone in California from starting a website under certain conditions.
Yeah. It seems to have a lot of issues with it, and one of them is the acronym. However, we know every good law has to have an acronym, right? So this is the True Origins of Digital Goods Act. That's TODGA.
It's not great.
That will never pass. You will never get TODGA through. It just will not work. It is not going to happen. Now, the article here at Ars Technica did point out that there is a similar law in Georgia, which has been used there, but that law only deals with physical goods. So obviously it's a little bit further reaching when you start trying to do it on the internet, especially in terms of interstate commerce. Because if you make and sell something within Georgia, well, that's not interstate commerce.
Yeah,
that doesn't really have anything to do with it.
Right. Georgia has the authority to regulate that, but once you starting into the online world, it becomes much more
exactly
complex depending on the scope of it. Because if somebody in Florida is able to sue somebody in California for not having, or if the I don't know if it would be a private right of action or it would just be the state. I mean, these are all things that would have to be looked at once the bill is passed or at least opened for review. You have to be able to look at whether there's going to be some jurisdiction issues in terms of personal jurisdiction. So if there's a website in California, can a Florida state actor tell them that they have to put their name if they're trying to commercialize some video on it? There's jurisdictional issues because if a person in California isn't doing any business there, there's personal jurisdiction issues. So
yeah,
go ahead.
And then one other thing that was pointed out was this applies even if you're only distributing your own content.
Right.
It doesn't matter if you are Mega Upload 2 or if you are Jonathan Bailey releasing the soothing sounds of Calico's howling in the background.
Oh yeah, I'd buy that.
Oh no, you wouldn't. No one will buy that. But the point being, it doesn't matter if you're releasing any kind of commercial recordings, even if you're giving them away but releasing quote unquote commercial recordings, you still have to be not anonymous. So it's an important thing to note there. We've chatted about Mega Upload a little bit. Quick update there, and this update should shock absolutely no one who's been following the saga. This step was so absolutely predictable that even an NBA referee could see it coming.
The final nail in the coffin of of all the seized assets, all the monies.
Well, maybe, because basically we talked previously about how the U.S. government had gotten Kim Dotcoom declared a fugitive, and when you were declared a fugitive, you lose the ability to use U.S. courts to defend your seized assets. If you want to defend your seized assets, you have to present yourself and subject yourself to the jurisdiction of the court, basically. And Kim Dotcoom has not done that. He has been fighting his extradition in New Zealand, and he's been fighting it through the legal process. It's not like he's hiding in a cave somewhere. What is with people hiding in caves in this episode? He's not on the run. Not that Kim Dotcoom runs very much, but I couldn't resist. But basically.
Hello.
I don't know. It was wrong. But the bottom line is he's not on the lam. He is just fighting his extradition through the legal process in New Zealand, but nonetheless, he was declared a fugitive here in the United States because he has not subjected himself to the jurisdiction of the court. And now the U.S. government is filing for a default judgment to seize all of Kim Dotcoom's cash, cars, and everything else. Basically everything he owns.
Right, so they already have it all, but they have it under basically like a temporary seizure. Now they want to take it permanently.
I don't know what. I guess auction it off. I mean, what you want to buy one of Kim Dotcoom's cars? Maybe we should go.
Personally, I wish I had the money.
Sure, he does have some nice ones. I want the one with the Mega license plate. I think that'd be nice. I don't remember what kind it was. I think it was a Lambo, but it'd be nice. But yes, I don't have that kind of money either. But yeah, and the problem with it is that the U.S. government will probably get this order, but then they have to take that to Hong Kong and New Zealand, where the assets actually reside, and get the courts there to honor their default judgment, which could be significantly trickier because Kim Dotcoom is actually in those countries, or at least is actively defending in those countries.
Yeah, that's the only question mark here. I think the U.S. courts are going to grant the default judgment. They kind of have to, since no defense has been made, even though they've tried to make a defense. The whole fugitive rule barred them from doing that. The only question is whether New Zealand and Hong Kong courts are going to honor
Yeah.
these forfeitures and these judgments. I think they will.
Yeah, it's gonna be. It's a big question mark, but we'll probably find it out soon enough. All right, and our final story
Final
this
story.
week, Requiem. It's time for a moment of silence for the fallen, and that is Aereo in this case. Aereo, as we recall, was a TV streaming service, came up with a very novel legal theory that they could legally grab, rebroadcast, and record over-the-air broadcast television on behalf of their subscribers if every subscriber rented an antenna. These tiny, dime-sized antennas. They actually did pretty well in the lower courts, put up a good fight. When they got to the Supreme Court, it didn't go their way.
They got smashed. And this I brought this up last week, right? And I was wrong last week. I told you that their trademark went for $2 million. And I thought, when I was thinking about it, $2 million is not a lot, but it's not nothing. But I was wrong. $2 million was the total haul they brought in for their customer lists, patents, trademarks, IT infrastructure. I mean, yikes.
Yeah, I mean, this is money that TiVo could have scrounged up by just shaking down their couch cushions. And, here we are, and that's all everything was worth. Now, TiVo, we were correct here, that TiVo did acquire the rights, the trademarks.
They did, yeah.
So we do not know what they actually plan on doing with it. But yeah, the rest, I believe the patents went to some generic firm, if I remember correctly, some super generic company that I don't remember the name of, and I'm trying to find it in the article.
Patent risk management firm RPX.
Yeah, do you want a more generic name than that, really?
Probably.
I've already forgotten, and I'm staring at it. It's like it's like it's like oof, it's gone already. You see, it's amazing. It's the darndest thing. Yeah, and they bought that, and basically, they were expecting. They said that they could bring in as much as $31.2 million, and they said, but the minimum we'll bring in is $4 million. Gonna have
they got money? Less than half of that money.
Yeah, I mean, this really is. To me, what this is, it's not really a knock on the legal element of it. Obviously, the legal case has been decided. The Supreme Court pounds the gavel. It's over. Of course, they actually don't pound. They have rulings, but you get the point. Point remains. It's pretty much over. But this is a huge knock on the idea of Aereo as a service and its viability, because if it had been truly valuable, if there had been a way to make this work legally, someone would have coughed up the cash to make it happen. They would have bought those patents. They would have bought them. I'm sure the physical product was also a part of this too. All the stuff that made Aereo. Basically, probably would have bought about 100,000 tiny antennas. But all
now, let's see, maybe you find an Aereo fire sale for what they didn't manage to get rid of.
I could use some new antennas. I don't know if I need 100,000 of them, but
do you? I don't know if you remember the Conan getting kicked off of the Tonight Show drama. I don't know if you followed that.
I remember that. Yeah.
One thing Conan did was one on Craigslist, and he's like, "For sale, like Tonight Show, barely used." So I'm expecting to find for sale 100,000 small antennas, barely used. Somewhere.
Must bring your own computer and motherboard.
Yeah.
and monitors. Yeah, it's it was very amazing what they quickly built. It said here they had raised about $100 million from their investors, including Barry Diller. And Barry Diller is not a moron. That is a very smart, very wealthy man.
That's venture capital. Sometimes you put venture capital into Snapchat and then you're worth $1 billion, and sometimes you put venture capital into Aereo and you take a bath.
Yeah, and sometimes you put it into WhatsApp, and then you're worth 19 billion. I'm still not sure how that one worked.
Yeah, I actually think Snapchat was looking for like an $18 billion valuation. So
Really? Good
yeah.
Lord.
Well,
Yeah, I don't
yeah,
get
they
I
said
don't get
no to
valuation. I
bleeding.
just do not understand valuation.
Well, a lot of people theorize that we're in the middle of another tech bubble. Which I
You think?
think I do think so. I mean, there's only so much that access and data can do for you when everyone now has access and data. Facebook has
Yeah.
access and data. Google has access and data. Snapchat has access and data. WhatsApp has access to data. And the income on, well, everyone obviously except Google because they're making a fortune, but WhatsApp isn't making money, and Snapchat isn't making money, and Twitter isn't making money. So like at the end of the day, some of these data and reach companies there's only so much room, I think,
Yeah. I
for
agree.
that business model to
Well,
be
I
in the
mean,
billion.
and the part that blows my mind is I'm not knocking WhatsApp, I'm not knocking Snapchat, but these are things that competent programmers can hammer out pretty quickly and build a clone of and start their own service.
Well, I don't know. I mean, there's no question that these are massively successful,
Yeah.
entrepreneurial, brilliant, really visionary people because they did it. They did
Yeah,
it
they
before
did it,
everyone else did.
and they did it,
My
and they not
issue,
only that they did it, they marketed it, they grew it, they did all the things right. But is
exactly.
that really worth 19 billion by
Right, that's the
itself?
question. Is that are we in the middle of a bubble? Are all these tech companies massively overvalued?
Yeah,
That's the
I
question.
agree completely. Well, anything else? Any final thoughts?
No final thoughts from me other than hello to all of our listeners out there, and
Yeah, we're trying to get back on schedule. This is actually 1 week later, almost exactly.
yeah, we're
Actually, it is
back on
exactly.
schedule, and hopefully I'll be able to see and talk to some of you guys in the near future.
Yeah, so on that note, everyone, thank you very much for joining us. Once again, my name is Jonathan Bailey from the site Plagiarism Today, and username Plagiarism Today at all the social media properties, Twitter, Facebook, Google+, probably have an Instagram. Don't know about Snapchat, but you get the idea.
Yeah, and
Don't Snapchat me, seriously.
do you have Snapchat?
I probably do, but I do not know what my username is. I have not used it actually in like years.
Yeah, I have it. I enjoy it. It's a lot of fun. Anyways, I'm Evan Sherris, copyright trademark lawyer and commentator extraordinaire, and we'll see you guys next week.
See ya.